inclusion of the condition was the result of an agreement between the municipality, SAW, and Sululumanzi, negotiated on equal terms. The third aspect, which I will address more fully, is the consequences of Buchle's admitted failure to exhaust the available internal remedy to it, which was an appeal under Section 62 of the Municipal Systems Act, and as required, we say, by Section 7.2 of PAJA. Braingear's position is that that failure should preclude its review. It did not apply for any exemption from the requirements of Section 7.2 of PAJA, nor did it make out a case that exceptional circumstances existed which would warrant such exemption, even had there been an application. The fourth ground which I address then is the particular review grounds which are targeted at Braingear. Those relate to alleged conflicts of interest on the one hand and a lack of technical expertise on the other. In summary, and again, this will be fleshed out with reference to the record more fully, Braingear's main argument is that the complaint of Buchle Waste ignores the fact that nowhere does it allege any conflict of interest involving the municipality. Instead, the conflicts are said to arise because of the relationships and connections between Braingear, SAW, and Sululumanzi. Braingear says, moreover, were fully disclosed by it in its submission in the process, as it was required to do when it made such submission. Further, that the uncontested evidence of Mr. Mabuza and Mr. Shongwe, and Professor Shongwe, pardon me, was that they played no role in the selection process, in any event. As to the question of technical evaluation on experience and ability, that was undertaken in terms of an agreed set of criteria which were applied by PwC, who acted independently in so doing. And the critical point which I would emphasize on that score is that there is no challenge before this court, there was no challenge before any court prior to this court to those criteria. So what Buchle seeks to do, impermissibly I submit, is complain about the proper application of the evaluation criteria, and it cannot do that with respect. Finally, then, I address the question of remedy and very briefly touch on the question of costs. I've already addressed the only additional point which I wish to make about the question of whether there was a decision, and I leave that and move then very briefly to the question of whether, if there was a decision, it was the exercise of a public power. And that only to make the following succinct points. With reliance on the well-known decision in SAFU, that one must look at the source of the power, which is not necessarily decisive but is a relevant factor, so too the nature of the power, its subject matter, and whether it involves the exercise of a public duty. Also, how closely related it is, on the one hand, to policy matters, which are not administrative, and on the other, to the implementation of legislation. I would pause at that point and emphasize, with respect to the question of implementation of policy, that the question of the role and the importance of the legislation providing for transformation and BEE, with respect, I submit, has been somewhat understood in this matter, misunderstood in this matter. And I say that because what the record shows is that SAW, which was the party seeking the consent to a change in control, itself had a level 2 BEE rating. And I would ask the court to note the document which was produced by SAW. It was produced at a time when there was a discussion about the inclusion of a local BEE partner, and that is to be found starting at page 637, but the relevant part is at Core Bundle 7, page 642. And proceeding from the point of departure that the change of control itself would significantly transform positively the shareholding in Silulumanzi, what the municipality wanted in this case was the inclusion of a local BEE shareholder. And there we see at page 642, paragraph 4.3, that, and I'm quoting, "You further indicated that whilst legally there is no requirement for local City of Mbombela municipality resident businesses shareholding further to that of employees, you have a political mandate pertaining to the choice of local shareholder and quantum of shareholder and of shareholding." And at 4.5, we see that the point is made that the new shareholder is 100% South African and has very strong BEE credentials. And so I submit with respect that that points to the municipality's preoccupation being a political one in the inclusion of a local BEE consortium, rather than being sourced in the BEE Act at a broader level requiring transformation of the shareholding. Returning to the question of public policy, and Justice Chiki, the question was raised by you whether there is a point of principle that the court can look to when identifying whether the exercise of a contractual right is a matter of public power. And I'd submit that from the point of departure that there is no bright dividing line, the majority decision in the Sandparks case by Justice Dambuza provides such a principle. And in that case, the court considered an accelerated felling program, and it found that the contractual right included the right in terms of Section 27 of the National Forestries Act to lease a state forest, and Section 23 providing for the felling of trees for lumber. And this felt to be considered alongside Section 55 of NEMPA, which placed an obligation on Sandparks to manage all existing national parks to protect, conserve, and control them, and the requirement of the lease itself in Section 40, which called for public participation. And on that basis, the majority concluded that the contractual rights and responsibilities arising from the lease agreement also fell within Section 55 of NEMPA. And my submission would be that in this case, there is no such mirroring, if I may use that word, of the change of control provision in the concession agreement with any provision in the Water Services Act. The power to conclude a contract is contained in Section 19 of that Act, but it's a bare power. There are regulations promulgated in terms of that Act which talk to the contents of the contract, but none of those regulations deal with the question of shareholding. And so I say, respectfully, that in this case, the exercise of that contractual right is not one of a public power. The question of internal remedies. That's a requirement of Section 7.2 of PAJA. I've already identified the section of the Municipal Systems Act which is relevant. The first mention by Buchle Waste of internal remedy comes as a result of the decision, which was a reason why an internal remedy wasn't appropriate, and further because of the municipality's stance expressed in the review proceedings that it did not see anything wrong with its acts, an internal appeal would achieve no purpose other than delay. The High Court didn't address the question of internal remedies. The SCA essentially upheld Buchle's arguments. Braingear disputes these conclusions. It says that no rights vested in it as a result of the confirmation of the condition. it was not a party to any decision of the municipality. Furthermore, the municipality's stance in the review litigation can never be used as an ex post facto justification to conclude that an appeal would have been a waste of time. But the critical point is that no exemption had ever been sought by Buchle. The principles applicable to internal remedy are well established. In our heads of argument, we refer to Koyabe. We also cite Gavric and Dengetenge. And the point that I would make in this court is that the findings in those cases, in some instances on application, in Dengetenge dealing with a matter where there wasn't, but that exceptional circumstances were nonetheless found to exist, are so far removed from the facts of this case that there, with respect, can be no finding that there are exceptional circumstances for Buchle waste in its position which would warrant an exemption being granted, let alone one granted where there is no antecedent application. Then turning to the aspect of a conflict of interest, I've already emphasized that it is the municipality whose decision has been taken on review, not any decision of any other party who was involved in the process leading to Braingear's selection as a PE shareholder. Buchle Waste contends that as a result of the fact that there was a board member, Mr. Van Aert of Silulumanzi, who sat on the same board as Professor Shongwe, and because Mr. Mabuza worked for Silulumanzi, although it's common cause that he resigned before any bid was submitted, that Braingear could not lawfully have participated in the invitation or lawfully been selected as a BE partner. And that's to be found in its affidavit in Core Bundle 1 at page 65, paragraph 48. Braingear answers these contentions. Mr. Mabuza had resigned from Silulumanzi because he had a strained relationship with Mr. Van Aert. Braingear made clear the roles of Mabuza and Professor Shongwe as they were required to do, and they signed declarations of interest which can be found in Core Bundle 3 at page 220 and 224, respectively. And I would ask that the court note particularly the terms of that declaration, which are that, and I quote from paragraph 1.1 at page 220, any legal person, including persons employed by the key stakeholders or persons having a kinship with such persons employed by the key stakeholders, including a blood relationship, may make an offer in terms of this invitation. So the mere fact of relationship is not enough to disqualify a bid. What may result in disqualification is an undisclosed relationship. But in this case, that is simply not the factual matrix before this court. Braingear further says that it didn't seek the assistance of any party in the process, and that Shongwe, although he served on the board of Silulumanzi, played no part in the selection process of a bidder. Later in its papers, Buchle Waste goes even further. It says, and this is at Core Bundle 6, at page 588, paragraph 198, that Braingear, or it's alleged that the SEMCORP parties had decided when Braingear was incorporated, possibly as early as April 2018, that Braingear would be selected no matter what happened in the selection process. At Core Bundle 6, page 574, paragraph 124, it alleges that the directors of Braingear caused their own associates at SEMCORP Silulumanzi to purport to evaluate them on inter alia integrity. And on this basis, SAW and Silulumanzi are alleged to have been referees and players at the same time without the involvement of the municipality. But there's simply no factual basis for these claims in light of the undisputed and undisputable facts that I have set out about Brain Gear's position in the bid. Moreover, the specific question whether there had been any favoritism was considered by the municipality. There was an exchange of correspondence on the 12th of September, the 16th of September, and the 17th of September, and that can be found at Appeal Record Volume, as opposed to Core Bundle, Volume 2, pages 185 and 187. So the municipality applied its mind to this question, and despite that, it was satisfied and gave the consent on the 19th of September. That addresses then the question of conflict of interest. I've already touched on the fundamental basis on which Brain Gear says the question of its alleged lack of technical expertise is flawed, and that is because the criteria against which it was evaluated were agreed to, and it can't then complain about the application of those criteria. The Supreme Court of Appeal upheld Buchle's argument that Brain Gear lacked technical expertise. It found that it had no track record and it was not an existing service provider, and it had no experience or track record. That's at volume 8, page 774, paragraph 45. But the simple point is that Brain Gear never claimed to be an existing water service operator. It made clear in its submission that it was a special purpose vehicle incorporated specifically for purposes of the bid. What it did, and you will find this at Core Bundle 3, page 217, is rely on the experience of its members, who undoubtedly had significant experience in the water industry. The evaluation criteria, which can be found at Appeal Volume 2, page 159 to 162, specifically provide for evaluation against the experience of the shareholders and their industry experience as part of the evaluation. Those are the evaluation criteria that were applied and against which Brain Gear was evaluated. I point out that Buchle itself was evaluated as having very limited water expertise. And that can be found in Saw's memorandum to the municipality at volume 5 of the appeal record, pages 537 to 539. With respect, therefore, both the High Court and the Supreme Court of Appeal erred by upholding challenges that amounted to an invitation to ignore the evaluation criteria and to look behind them, when that should not have taken place, and which we say respectfully does not apply the principles of Bata Star of judicial deference in decisions of such a kind. Finally, then, in conclusion, I deal with the question of remedy and touch on the question of costs. I start by identifying the fact that there is a tension between the May order, which was the order by agreement taken at the beginning of proceedings, and the High Court's subsequent order in August of that year, and the Supreme Court of Appeal's order granted in the appeal against that case. I would submit that, as has already been identified by this bench, the legal consequence of a finding that the condition has not been met, because it has been reviewed and set aside, is to undo all of the transactions which flowed from the fulfillment of that condition. My learned friends, on behalf of SemCorp Netherlands, set it out particularly succinctly at page 17 of their written argument, paragraph 53. They offer a different interpretation of the Supreme Court of Appeal order in respect of the tension between the May order and the review, but at page 17, we say that that is the correct explanation of the consequences of a review. And it's for that reason that in this case, and here I refer to the written argument filed on behalf of Brain Gear, specifically from page 42 and onwards where we deal with remedy, that this is a case, and here I refer to page 44 of the written argument, where it is an instance, such as others that have preceded it, where courts have declined to set aside an unlawful administrative act where the circumstances have demanded this result, or, and in so doing, that considerations of public interest, pragmatism, and practicality should inform the exercise of a judicial discretion whether to set aside administrative action or not. The facts which we say are relevant to the question of remedy are addressed at length in our written argument. I'm not going to repeat them. My learned friend, who has already addressed the court, has identified what some of those are, including the execution of the various agreements which followed the approval of the condition, the fact that that involved, particularly in Braingear's case, significant finance and incurring obligations to its financiers, and that it has thereafter participated at board level and in the management of Silulamanzi, and that a review would have the effect that it would undermine or place in question the conduct of the board in Silulamanzi from 2018 onwards. We say, therefore, and we follow the suggestion of our learned friends, that an option open to this court, should it uphold the review, would nonetheless be to suspend its operation for the remainder of the concession agreement, given in particular that that agreement is now nearing its end in 2029. The concession agreement itself is not before this court, though, and so I mentioned, because it was part of the record, it was before the courts previously, that the concession agreement does contain a provision which would permit of extension between the parties. And to the extent that any order of suspension may be made, that is something which this court will take cognizance of. Alternatively, and if the court is not minded to make that order, I would submit that this is a case akin to the decision in Allpay to which we refer in our heads, where there's an absence of factual information which is relevant to the question of remedy. Bearing in mind that the affidavits in this matter were finalized in 2022, that there's been a further 4 years since then, those facts about what has happened in that intervening period are not before the court. Furthermore, pardon me, Silulamanzi is, of course, a water service provider, and this court will be cognizant of any risk that a review having the effect of placing the shareholding in issue for that entity may be disruptive on that part of its services, which are undoubtedly of a public nature, providing water services. Then finally, in my remaining 30 seconds, I would simply make the point that although pertinently raised before the Supreme Court of Appeal, the question of an appropriate remedy or the question of an appropriate cost order was not considered by that court. It made a cost order against private litigants, notwithstanding that the litigation was clearly constitutional in nature. My submission would be that that doesn't follow the established jurisprudence of this court, and that this court may correct that, if nothing else, when it grants judgment in this case. Those are my 30 minutes.
Good time. Thank you, Mr. Mtika. I just want to, on the question of conflict of interest.
Yes, Justice.
Professor Shongwe was the chairperson of, or is the chairperson of.
So he was at that time. I can't confirm if he still is, but at the time of the bid, he was the chairperson of Silulamanzi.
And he was also a director of brain care.
Yes, and shareholder.
Now, as a chairperson of Silulamanzi, the company that was supposed to be selling the 28% shareholding, what was his role in the entire process?
Well, firstly, Justice Mhlahla, Silulamanzi itself was not the seller of the shares. The seller of the shares was Semcorp Netherlands, held both directly and indirectly. So the parties selling the shares were on the one hand the SemCorp Netherlands, on the other, the locally incorporated SemCorp entity. So Sello Manzi wasn't implicated at that level. What the professor says is that he had no role in the selection process at all. So he played no part in it.
There's a letter in CP3, page 228. It's from Sello Manzi, addressed to Mr. Shongwe, where they are telling him about the outcome of the application.
Yes.
And he is a chairperson
Well,
of this same company.
Justice Mplantla, we must distinguish, there are two Shongwes in this matter. There is a Mr. Shongwe, who is in fact present in court today, and there is a Professor Shongwe, who are no relation to each other. This letter is addressed to Mr. Shongwe, not Professor Shongwe as chairman.
So the Mr. Shongwe here is not the same one who is the chairperson of the,
No, Justice Mplantla,
company?
he's not.
Okay, then I'm covered.
He is the very good friend referred to in Brain Gear's affidavit. It's not Professor Shongwe who is a very good friend, it is Mr. Shongwe, who had no role in any of these entities.
When you started your address on the conflict of interest, you said it is a decision of the municipality that is taken review,
Indeed, sir.
not the other parties. What do you mean by that?
That before the municipality took its decision, if, and this is without conceding that it was a decision, but for sake of argument, assuming the decision to have been on the 14th of November or the 19th of September, before it took that decision, there'd been a process with PwC, an evaluation. Saw and Sello Manzi then had a meeting with the preferred bidders, Brain Gear and Buchler Waste, and they had carried out their own additional evaluation. And then they made a selection. And that selection was Brain Gear. So the point is that there's nothing in those decisions which has been challenged by Buchler Waste. They can't be challenged because they're the decisions of private parties. But it's the municipality's decision thereafter to accept the selection and to confirm that the condition in the June resolution has been met that is the only decision that's relevant for purposes of the review. And therefore, where there's no allegation of any conflict of interest involving the municipality, the point is something of a non-starter, I would submit.
If there's an allegation of conflict in the process, a process that is, at the end of the day, accepted by the municipality, is that party not entitled to raise those issues?
Well, what it would have to do is show that the decision maker was conflicted in making the decision, or that there'd been some sort of favoritism which impugned the decision of the municipality. But that's what is absent in this case. There's no such allegation. There's merely a complaint that Mr. van Aert and later Mr. van Wyk, who represented an entity called Mergence and thereby became a director of SAW, sat on the same board as Professor Shongwe on the one hand, and that Mr. Mabuza was employed by Sello Manzi. But that's as far as the allegation goes. It's possibly at best the appearance that there may be a relationship between parties who are involved in the process. But factually, Brain Gear says it didn't seek any favors. The members and directors had no role in the evaluation. So those are the facts on motion proceedings where final relief is sought that I submit must be upheld. And the inferences and suggestions of Buchler Waste are no more than that. It suggests that there may have been a conflict. It can't show what that is in any concrete way.
Then there's the concern that was raised about the experience of Brain Gear.
Yes.
You are saying there were a number of entities or groups that came together.
Yes, at the level of the membership, the shareholding and directorship of Brain Gear, the parties which it included in its submission had significant direct experience in the type of services which Sello Manzi renders. So at the level of control and ownership, there was a vast wealth of experience. Of course, a special purpose vehicle registered to make a submission has no track record. But that clearly doesn't mean that it's excluded from making a submission. And I would also add on that score that Braingear is not the party providing water services. It's a party who wanted to become a minority shareholder in a company which provides those services. What SAW wanted at the level of a shareholder relationship were shareholders who could add value. And clearly, therefore, the shareholders of Braingear and its directors could do that. They could sit on the board. They had the experience necessary to add that kind of value. So it's entirely rational, even though there is no challenge to the evaluation criteria, to evaluate submissions on the basis that one looks to the experience of the directing minds of that entity rather than the absence of a track record of that entity.
Justice Chikwe?
Just something small, Mr. Whitaker. I just want to be clear in my mind whether we get to conflict, to the issue of conflict, if we decide that November date is not the right date.
No.
And if we decide that perhaps the High Court should not have granted condonation, do we get to the issue of conflict of interest?
No, you're quite right, Justice Chiki. So in the order in which I have presented the arguments and which my learned friend presented arguments, if there's no decision, then that's the end of the matter. If there is a decision, but it's not one of a public exercise of a public power and of an administrative nature, again, that's the determining factor in this matter. Or if the court finds that there was either an unreasonable delay or that the failure to exhaust internal remedies on either of those bases, if the court comes to that conclusion, then we simply don't get to the merits of the review at all.
Thank you, Justice Mzansi.
Thank you. Questions? No one. Looks like.
Mr. Whitaker, I just wanted to canvass in Vuchle's argument, they suggest that the Braingear was only, Braingear, the entity that was incorporated and held the shareholding,
Yes.
was only so incorporated in November following the consent of a decision of the municipality.
That's correct, and I would just take a step back to distinguish between Braingear Investments, who is before the court, who made a submission in the process for potential selection as a local BE partner to SAW. That entity was incorporated in April for purposes of the bid. The aspect that Vuchle raises, and it's part of the evolution of its case that we see in its, I think, second supplementary founding affidavit, is that the entity which ultimately held the shares is an entity called Braingear Investments South Africa. And that entity, it's correct, was incorporated in November, as you have stated, Justice Savage. But Braingear provides a very full explanation for the role of Braingear Investments South Africa. It is, in very simple terms, or in very succinct terms, a special purpose vehicle created at the instance of Braingear's funders to secure that funding. So Braingear, the party before court, owns all of the ordinary shares in Braingear Investments. Braingear Investments, however, issued preference shares in different classes to its funders. And those two, obviously, my submission is that Vuchle conflates them. And so the question of when Braingear Investments was registered doesn't really take the matter further. For full references on this aspect, we deal with it at page 39 of our written argument and following.
It seems to me that reading from Vuchle's argument that there's a suggestion of nepotism or certainly a conflict of interest that the municipality in exercising its oversight function had not honed in on. And I mean, to what extent could it be that in not doing so, that it failed to provide that sort of oversight that was needed?
So, my lady, Justice Savage, I haven't addressed that issue which my learned friend spent some time on, but I did mention in the context of the conflict argument the fact that when concerns were raised about the process, as they were in correspondence that took place shortly before the confirmation of 19 September, that specific issue was raised by the municipality. It wrote to Saw and Silulumanzi seeking certain assurances. Saw wrote back and confirmed that there was no such favoritism in the process. So the decision maker, having considered that issue and then made a decision about it, I would submit puts it beyond a review by a court.
Now, when you put the shares in a different entity, then how's that process undertaken?
Well, Brain Gear is the party who has all of the benefit of ownership. The use of Brain Gear investments is only as a financing structure to give security to the financing entities. And what I would add to that, to show with respect that Buchle's argument is entirely opportunistic, is that it proposed the very same funding structure using a special purpose vehicle, holding the shares in that vehicle as security for the funders. And that you will find referenced at CB Volume 5, page 515. It's also addressed in our heads at page 40, paragraph 128.4. So Brain Gear's position is that this misunderstands an ordinary commercial structure adopted by funders used all the time in financing large transactions such as this, where they wish to have the security that the ownership is ring-fenced in a special purpose vehicle. But Brain Gear owns 100% of the ordinary shares of that vehicle. It's the party who's received all of the benefit. It's the party who's appointed members to the board and employees of Silulumanzi. And in that sense, it is clearly the party who is the partner in the transaction. As it please the court.
Ms. Hoffman?
Thank you, Justice Mhlantla. If we may just have a moment to organize ourselves. Thank you, Justice Mhlantla, members of the court. I stand before you today in a rather unique position. I represent a client who settled its case almost 4 years ago before the High Court, but still finds itself participating in appeal hearings because it seems that somehow, despite that settlement, it has lost on 2 prior occasions. Justices, Semcorp Netherlands used to own shares in Silulumanzi, a concessionaire to the Mbombela municipality. It sold those shares in 2018 to South African Waterworks. Now, in order to do so, it needed the municipality's consent to that change in control in the concessionaire, from Semcorp Netherlands on the one hand to SAWW on the other. It obtained that consent in June of 2018. The consent had a condition attached to it. It was a condition that SAWW had to go out on a process and select a local BEE entity to subscribe for 28% of the shares in the concessionaire. And that condition had to be fulfilled within 90 days. It was, and the consequence of that is that the sale purchase agreement between Semcorp Netherlands and SAWW became itself operative. Semcorp Netherlands sold its shares to SAWW and it exited the country. It played no role whatever in the selection of that 28% shareholder. And its sale to SAWW was the precursor, the necessary precondition for those 28% shares ever being available for anyone to subscribe for. Justices, Buhle Waste was one of the contenders for those 28% shares in Silulumanzi. It was unsuccessful in the bidding process, though. Brain Gear, its adversary, its other contender, was chosen to subscribe for the 28% shares. And aggrieved that it had not been selected, Buhle Waste approached the High Court to review something that it thought would get it either another opportunity to bid for those 28% shares or the shares themselves, because at a point in this case it was seeking substitution relief. Justices, it bears emphasis at the outset, no part of Buhle Waste's case strikes at the SPA. Why? Because it needs that sale purchase agreement to have become operative so that the shares move from Semcorp Netherlands to SAWW so that SAWW had them available for the likes of Brain Gear or Buhle Waste to bid for. Justices, against that backdrop, I propose to deal with three things in my argument today. The first is to spend some time in the pleadings themselves. This court reminded all of us in Garvis that precision in pleadings is not pedantry. It is in fact an instance of certainty in our law. And it is for that reason that we must hold review applicants to their pleadings. Those pleadings confine the sum total of what a review court may look at and the relief that it may give. And Justices, in that first section, I also propose to spend some time on the text of the resolution itself, that 28 June resolution, because it has some importance in the proper evaluation of this case. Justices, second, I propose to explain Semcorp Netherlands' unusual position before you today, because it is a conditional applicant for leave to appeal. It is conditional because of what can and cannot potentially be made of the Supreme Court of Appeal's judgment and order. You will have seen from our application and our heads of argument, there is an analysis that needs to be done of the Supreme Court of Appeal's order. If you agree with us that it has left intact the May order and as a consequence has left intact, fully binding, operative and enforceable the sale purchase agreement, then my client is actually not an applicant before you today because its position was sufficiently protected by the Supreme Court of Appeal's order. It is only if you disagree with that interpretation of the Supreme Court of Appeal's order, along the lines that, amongst others, the applicants before you today say there is some potential unwinding of that SPA living in the Supreme Court of Appeal's order, that my client becomes an applicant for leave before you. And that would move me, should we get there, to the third part of my argument, to explain to the court today that if the effect of the SCA's order is in any way to render undone the sale purchase agreement, then we make submissions as an appellant. And we say that the Supreme Court of Appeal's order should be overturned, and either the May order of the High Court should be reinstated, or the review at its outset should have been dismissed. Justices, if I may then begin with the pleading point. There are 2 points on pleading that I believe it's important to emphasize to the court. The first relates to what Buhle Waste itself, in its own papers, reveals about what it knows and knew about the decision-making process. For that purpose, I'd like to take the court to 2 instances. The first is a letter, my learned friend Mr. Marcus referred to it, that Buhle Waste writes to the municipality on the 25th of September 2018. You'll find it in volume 1 of the core bundle. And first of all, you'll find it referred to in its founding affidavit, but I think we should maybe go to the letter itself at CB 41 to begin with. It's CB 41 in volume 1. This is the letter that Bootley Waste's attorneys write after they've been told that they were unsuccessful in seeking to subscribe for the 28% shares. It's dated the 25th of September 2018. It references the fact that there was a concession agreement in terms of which a change of control was required to be approved by the municipality. And then over the page at page 42, Bootley Waste says, the city of Mbombela granted its approval conditional upon Silulumanzi obtaining a 28% Mbombela-based BEE shareholder. What's important about this letter is that it's being written in September of the year, and it's Bootley Waste saying, we know, municipality, you granted approval, conditional approval to that change of control, and it had a condition, which was that there needed to be a 28% local BEE shareholder. And then it goes on to raise complaints about that process and to call on the municipality to answer its complaints. But the important point is we're in September. We haven't even reached November. And Bootley Waste knows there's a decision that's been taken. It knows it had a condition attached to it. It knows it lost out on being the contender for the 28% shares, and so it's starting to complain to the municipality about that very fact. And Justices, if we then jump ahead one more month to the 25th of October 2018, I'd like to draw the Court's attention there to the second supplementary founding affidavit of Bootley Waste. You'll find that in volume 4 of the core bundle, at page 315. Justices, this is the second supplementary founding affidavit of Bootley Waste. Bootley Waste tells us that this is at paragraph 88 on that page, that the municipality responded to that letter I just took the court to, in which Bootley Waste had complained about the decision that was taken. And it says the following at paragraph 88. The municipality responded on 25 October 2018, effectively distancing itself from the selection process. As the municipality showed no concern for the manner in which the decision was taken, Bootley Waste harbored doubts concerning the prospects of success on review. It is for this reason that Bootley Waste considered it prudent to try and obtain legal advice as to the prospects of reviewing the municipality's decision. In October of 2018, Bootley Waste is telling us it was meeting with its lawyers to get advice on how to review and on what terms to review the municipality's decision. We haven't even hit November yet. Justices, those two features of Bootley Waste's case only underscore why what one ends up with in July 2019 is, with all due respect, a misdirected and ill-conceived review application. It knew the decision had been taken in June. It knew it got to participate in a whole process to subscribe for shares as a consequence. It was aggrieved it didn't get them. It wanted to replace Brain Gear. And so it went to the courts to do so, but it framed its case in a way that could not get it there if any precision is applied to pleadings. Justices, the next aspect of pleadings is a point that I'd like to pick up in a question that Justice Rogers asked my learned friend, Mr. Marcus. It's about what happened on the 19th of September. Now, in Bootley Waste's heads of argument before this court, it says that my client, Semcorp Netherlands, alleged in the Supreme Court of Appeal for the first time that it was on the 19th of September 2018 that the municipal manager confirmed in writing that the condition attached to the consent had been fulfilled. And it goes on at paragraph 45.5 of its heads of argument to say that we made that argument without any pleaded basis. So there are two criticisms. We make it for the first time, and we make it with no pleaded basis. That is simply false. My learned friend, Mr. Whittaker, has already taken the court to the two averments in Bootley Waste's own founding affidavit and in the city's answering affidavit that made this point common cause on the papers. Justices, it's useful just to see that language in its own terms. So if we can call up the first, It's the first supplementary founding affidavit of Bootle Waste, and it's at Volume 1, Core Bundle 74. Justices, paragraph 67 on that page, Bootle Waste says, it appears that it was pursuant to this letter of 19 September 2018. Justices, that's the reference to the letter that Selula Manzi addresses to the municipality asking for the municipal manager's confirmation by signature that the condition has been fulfilled. And it says, it appears that it was pursuant to that letter from Selula Manzi that the first respondent, Justices, the first respondent is the municipal manager in this case, appended his signature and granted the consent. That's their averment, and that averment is answered by the municipality in Volume 2 of the Core Bundle. Justices, you'll find that at page 130. The municipality at paragraph 195 answers that paragraph 67 and says, I admit that on the 19th day of September 2018, the municipality granted consent. So, Justices, far from the point that we made about the 19th of September being the date on which there was confirmation in writing that the consent had been fulfilled, being unpleaded, is concerned, that is not so. As a fact, it was common cause on the papers that the municipal manager did what he did on the 19th of September and thereby satisfied the condition of the resolution. Justices, what does happen, though, in Bootle Waste's heads of argument before this court is they go through some detailed analysis of pages from the review record, the Rule 53 review record, that you have to go and find, not in the core bundle, but in the supplementary main bundle, and pull out of a review record some pages that they say underpin why we shouldn't take Mr. Mhlongo's signature on that date as being indicative of a person with sufficient authority to give the confirmation that the municipality was looking for. Justices, that you cannot do in a review. The law on that is trite. You must plead your case with precision. You must pull from a 53 record precisely the documents about which you want to make your case, and you must give the parties try to undo what happened in September C says conditional consent be granted with the specific suspensive condition that SAWW and Silulumanzi immediately after this council resolution commence with the process of obtaining a 28% Mbombela-based BEE shareholder in Silulumanzi and conclude this process within the prescribed 90 days from the date of the council resolution. It's the running of that process, the selection of the 28% shareholder that is confined by the 90 days. If you go down the page to F, that's another requirement of this resolution. It's that the municipal manager as accounting officer be mandated to confirm that the requirements above have been met as per the terms of the conditions of the consent. That is not stipulated as needing to be completed within the 90 days. It's a confirmation after the fact of the fulfillment that needs to be done by the municipal manager. And then if you go over the page to H, that's where the two get drawn together into a clause, but we say not necessarily with the impact being that the written confirmation had to come in the 90 days. And let me explain why that's so. H reads as follows. Should the suspensive condition stipulated in C above, that's the one about running the process and choosing the 28% shareholder, not be met within the 90 days from the date of council resolution, and written confirmation not having been issued by the municipal manager confirming that all the suspensive conditions for the conditional consent have been met, the conditional consent will automatically lapse and be of no further cause or effect and may not be relied upon by any party. We say it is possible to read that clause as making the running of the process and the necessity of that being completed within the 90 days, but leaving some greater latitude for the confirmation from the municipal manager following it. But Justices, it's important that I emphasize this. You don't need to get there at all in this case, because the common cause position on the pleadings is that on the 19th of September, well before the 28th of September when the 90 days would expire, the municipal manager did give the written confirmation that the condition had been fulfilled. Justices, it's against that backdrop of the pleadings and the points I made at the outset that Semcorp Netherlands and Buhle Waste found each other on the eve of the High Court hearing in May 2022. They found each other because, as Semcorp Netherlands repeatedly made the point in its answering affidavit, the SPA is not under challenge here. The SPA has to have taken effect and been operative for Buhle Waste's participation in this case at all to have become relevant. And so they concluded a settlement agreement, which was made an order of court. Justices, you can find that in numerous places in the papers. One of the easy places is in the Supreme Court of Appeals judgment, which you'll find in volume 8. It stipulated first, importantly, the scope of the review. What Buhle Waste was and was not attacking. It was not attacking the sale of shares agreement. It was not attacking the council resolution of 28 June. And as a consequence of that ambit of its review, it stipulated that the Semcorp Netherlands SPA and the June 2018 resolution were valid, enforceable, and binding. That was the language chosen because Buhle Waste never intended to undo that arrangement. And Justices, it's interesting just to look at their second amended notice of motion for confirmation of that. Because what you'll see, albeit that their substitution relief was not ultimately granted and there wasn't an appeal against its refusal by the High Court, it's a good indicator of what Buhle Waste's interest in this case was and the scope of its review. Justices, you'll find that in volume 4 of the core bundle, page 321. This is where it framed its substitution relief. This is an indicator of what it came to court to get. What it wanted at paragraph 4 is the consent decision to be set aside and substituted with an order authorizing the transfer of the shares in Silulumanzi from Semcorp Netherlands to SAWW, subject to a new condition that would allow it to subscribe for the 28% shares. Justices, nothing makes it clearer than that prayer of its own second notice of motion, that it never came to court to undo the SPA. It wanted that, it needed that SPA to be in place, and that's why the parties found each other. And Semcourt Netherlands, as a consequence, did not participate in that hearing in the High Court at all. We sat on a watching brief for the purpose of the hearing. But then 3 months later, the High Court hands down an order in which, amongst its provisions, it stipulates that pending reconsideration of the 14 November 2018 decision, the suspensive conditions in the resolution of 2018 have not been fulfilled. But that stipulation does all that unwinding work that Buchle Waste and Semcourt Netherlands were at pains to ensure didn't happen. That the SPA, no matter what eventuated in this case, would remain valid, binding, enforceable. And Justices, that is why Semcourt Netherlands became an appellant before the Supreme Court of Appeal. It was because of that tension between Clause 7 of the order of the High Court in August with what it had stipulated 3 months earlier in its May order. Justices, our first argument before you today as Semcourt Netherlands is that we actually did win in the Supreme Court of Appeal. We say we won there because of what the Supreme Court of Appeal said in paragraph 34 of its judgment. Justices, in paragraph 34 of its judgment, the Supreme Court of Appeal said a few things. It said clearly the May order is unaffected. It says the May order stands. It says as a consequence of that May order, the SPA is valid and enforceable. And it went on and said, there is no inconsistency between the May order and the High Court's order reviewing and setting aside the impugned decision. So the SCA's own understanding of the High Court order that it ends up upholding in part is that it can live alongside the May order. Well, Justices, if that is so, you've seen from our heads of argument how we say you have to read the May order compatibly with the 2 paragraphs of the High Court order that the Supreme Court of Appeal left in place. You'll recall what is left in place is the reviewing and setting aside of the November 2018 decision, and coupled with that, a remittal of the decision. Now, we say the only way to read that consistently with not doing any violence to the SPA, not undoing it in any way, is to understand that the remittal order must relate only to that part of the change in control that didn't implicate the SPA. In other words, what goes back is exactly what Buchle Waste wanted in prayer 4 of its second amended notice of motion. It's the process about who subscribes for the 28% shares. The only way to read the Supreme Court of Appeal's remittal, with its insistence in its own judgment that the May order remains valid, binding, it was never appealed against, is to understand that the remittal will cover a more limited thing than that which would strike at the SPA. Justices, if you're with Semcourt Netherlands on that interpretation of the SCA's order, then we are not an applicant for leave to appeal before you, because our application was always conditional. We said in the first place we actually did protect our rights in the SCA. Our rights live in the May order, and the SCA made it clear the May order remains operative. Justices, it's only if you're not with us on that interpretation of the SCA's order, and you regard that order as having somehow unwound the SPA, so that what goes back is the whole question of whether to consent to the change in control, whether to consent to Semcourt Netherlands, who exited this country 6 years ago, selling its shares to SAWW. If that is the import of the remittal order of the Supreme Court of Appeal, then we seek leave to appeal to this court. We seek to do so for 2 reasons traversed in our heads of argument in detail. The One is that the SCA then, despite saying it wasn't doing it, as a fact, overturned the May order, and it was not competent to do that because there was never an appeal against that order by any party. So we would seek an appeal before this court a reinstatement of that order. Alternatively, we say if you're even against us on that, the order that ought to have been granted by the High Court originally is a dismissal of the review. A dismissal of the review for all the reasons you've heard my learned friends address you on for the better part of the morning. Struck at the wrong decision, struck insofar as it struck at that decision late, and all the other arguments you've heard today. Justices, with 1.5 minutes to spare, those are my main submissions.
Thank you, Ms. Hosmer. Let's start with the orders of the High Court and the SCA.
Yes.
You've read the paragraph where the SCA explains what is supposed to be the case insofar as the SPA is concerned.
Yes.
And then, in its order, it sets aside paragraphs 3 to, I think, 7
Yes,
of the High Court and leaves intact paragraphs 1 and 2.
indeed.
My interest is in para 2
Yes.
of the High Court order, which says the request for the consent regarding change in control of Silulumanzi is hereby remitted to the municipality for reconsideration. What does that mean?
Well, Justice, it's capable of 2 readings, is my submission. The first reading is that everything is undone. And by that I mean even the part of the decision, not the condition that was imposed, but the original consent to control of Silulumanzi moving from SEMCorp Netherlands to SAWW. That, on one reading of this paragraph, is what goes back for reconsideration. We say that is not the correct reading of that paragraph because, as this court has said repeatedly, you read orders in light of the reasoning in a judgment, and that reasoning we find in paragraph 34 that I took the court to. And what paragraph 34 makes plain is that the May order must live alongside this paragraph 2 order. Now, what the May order said, amongst other things, is it defined the scope of the review, doesn't challenge 28 June, right? But it also defined the binding effect of the SPA. The SPA is something that took effect because of the consent to the change in control between SEMCorp Netherlands and SAWW. So you need to interpret too in light of almost a ring fence that's been created around the operation of the SPA, as well as the original consent that was given in June of 2018. And so all that is left, in fact, for reconsideration is that part of the condition attached to the consent, in terms of which 28% of the shares would become available for a local BEE participant. Justice, it's not I want to be frank, it's not easy to read all of that in, but we say it's the only way, credibly, to read what the SCA was doing in paragraph 34 with what the outcome must be of paragraph 2.
And the May order, that's the settlement that was concluded
Yes.
between
implemented. Remember, Clause C of the resolution mandates SAWW to commence a process to identify that 28% shareholder. That's the first time Buchle Waste or Brain Gear enter the story. They contend for those 28% shares. Buchle loses, Brain Gear wins, and Buchle wants to be the 28% shareholder. That's all this case has ever been about, despite imprecision. Yes, Justice.
If we have to clarify, take into account what the SE said in para 34, and if one has to, that is, if we agree with the SA judgment,
Yes.
you take para 34, what should we do with to clarify this order?
Yes.
To make it clear?
Well, we would say that there needs to be clarity as to what is remitted. And just, Nhlanhla, what may be useful is in volume 8 of the main record, you have both the SCA judgment and the High Court order
Yes, I have that.
next to each other, right? So if we go to page 778, you see what the SCA leaves in place is paragraph 1 and 2 on that page. Those two paragraphs would have to be adjusted to make it clear that what is set aside and what is declared unlawful is that confirmation that the 28% shareholding should be subscribed for by Brain Gear, and that part of the 14 November 2018 agreement is what is remitted for reconsideration under 2. Justice, if I may be permitted, I'd like to spend a little bit of time in the break coming up with actual wording for that purpose, and if I would be permitted just in reply to give that to the court. I'd like to give some thought in, and I'd like my learned junior's input on it as well. So with your leave, we'll give you some language that we say properly captures the effect of what the Supreme Court of Appeal was driving at.
Ms. Hoffman, can I just ask, this point you raised on the interpretation of paragraph H of the resolution,
Yes.
I know you say we don't need to reach it, but can I just say, ask, was this view of the meaning of the resolution, namely that the 90 days applied to the process which was being run by the private parties and not to the confirmation by the municipal manager, was that asserted anywhere?
Not to my recollection, Justice Rogers, in part because the factual position was that they both happened in the 90 days. So I suspect it wasn't. Again, we were not a participant as an arguer before the High Court, so we did not make that argument there, no.
Thank you.
I just need your assistance because I'm struggling to understand how the change of control could happen without the fulfillment of the conditions which were imposed by that resolution. Can you please help me with that? Because on my understanding, Sembcorp Netherlands could not transfer its shares until and unless those conditions were fulfilled.
Justice Nuku, I'm indebted for the question. It is so that the transfer of control consent given by the municipality was a conditional one. So, Justice Nuki, in that respect, you are absolutely correct with respect to say the municipality put the two together as part of its consent. It said, I'm going to approve this transfer of control if within 90 days, once Sembcorp Netherlands has sold to SAWW, SAWW identifies a 28% BEE shareholder to take up the 28% shares. Absolutely. But the actual change of control, the thing that precipitated the need for approval at all, happens before that condition is imposed. The need for it happens and the parties go before the municipality before this idea of a condition even exists. And that's why I emphasize the control happens when Sembcorp Netherlands sells to SAWW. That's where the change in control happens, because that's where Silulumanzi moves from being controlled by Semcorp Netherlands to being controlled by SAWW. The municipality tacked on a condition. It's the condition that Buhle Waste is interested in, and that's why I say if it succeeds at all in achieving any relief from any court, what needs to go back for reconsideration is that part. Who gets to subscribe for the 28% shares? It doesn't even want the condition to be removed. Remember, it only gets to partake in this whole arrangement if the condition is there, the transfer has taken place, control has moved to SAWW, the sum total of its complaint is how it was implemented. That brain gear was chosen and not it. That's what it struck at in this review. If it is to succeed, that's all that should go back. The running of the process to select whoever it wants. And what it's made clear, Justice Nuku, is the thing it doesn't seek, and the thing that no relief from any court can give it, is an unwinding of that original consent, an unwinding of the SPA being made valid, binding, and enforceable. It says categorically that's not relief it seeks. It may, as a matter of law, have difficulties with that, Justice Nuku, but review applicants choose how they frame their cases. They must be precise about it. They made an election here. They said the thing we're not attacking is that SPA. The thing we're not attacking is that SAWW got the 100%. So they want all that this goes back to have done is that last little step revisited.
Yes, what I'm asking is that possible? Because the conditions are either fulfilled or they're not fulfilled.
No.
So if there's something that must still be remitted, that may tend to suggest that the condition has not been fulfilled, in which event then the whole transaction has
Justice Nuku,
not been effective.
that outcome is not legally pure, would be my submission. But remedies that courts grant all the time are remedies that don't subscribe to legal purity always. They are remedies that make sense based on the facts before the court and the framing of the review that comes to it. So there is a respect, Justice Nuku, I must not be heard to say otherwise, that this unwinding impact, because it was a suspensive condition, at a pure matter of law, can unravel back to the 28th of June 2018. Absolutely, you won't hear differently from me. But what Buhle Waste never wanted was that. That case has never been met. My client has never gone on oath and run a remedy argument, and I can tell you it would have taken pages and pages about the fact that its holding company is listed on the Singaporean Stock Exchange. It's been out of this country for by now 7 years. You can't possibly unwind this thing as a matter of remedy to go back to the position where the whole consent is undone. It was never asked to answer that case. So all that is left is in a remedial discretion of a court. A court absolutely competently can give this more limited remittal remedy. If it finds that Buhle Waste's complaints about that last process are valid, it finds that it struck at the right decision to get at this relief, then it can circumscribe the remittal to make sure that the only thing that is touched is that last part of the process. And Justice Nuku, in doing that, it will keep in place the May order against which no party has ever appealed.
I couldn't find in the judgment of the High Court a reference to the May order.
There is none. Justice Mhlantla, I think there was a line in our heads of argument where we said we didn't know what happened to the May order by the time of the August order of the High Court. You are absolutely correct with respect. That judgment does not once refer to the May order, which was in part why my client was so bemused by the August order. It never grappled with how that May order could then live alongside its reasoning, its remedy, the outcome that it gave.
That was a settlement agreement, and the court could not set it aside.
No,
It was made an order of
it was made an order of court. On the first day, we appeared, The agreement was made in order of court, and in fact, what prompted my client to, well, we initially sought leave to appeal from the High Court, it was declined. We then petitioned the SCA, and it did so precisely because the status of that May order with no reference in the judgment, and a judgment that started to unwind suspensive conditions, at least needed the clarity of a higher court.
Thank you, Ms. Hofmeyer. The court is going to take a lunch adjournment for 30 minutes. We'll come back at quarter to 2. Court adjourns.
See what it looks like though. Alright, that's part two, but this part one now. Oh, let's see part one. Was it? Look at the website. Yeah. Page. Let's do it. This part one was it. This part one. You know how dangerous is that? Yes. That mic is not off by council. You find whatever these guys are saying is broadcasting. That's a good check. You switch it off. I'm just hoping there's a way just to censor it. That mic is not off. Nobody can hear us yelling. Whatever these guys are saying, broadcasting. Yes, Jimmy, yes. Switch it off.
call upon council to confirm that his consent to the transfer has now become unconditional.
Yes.
That is now 4.2. And then at the bottom, where that PP, Mr. Mhlongo signs, where the municipal manager was supposed to be signed, was supposed to sign, it says that the city of Mbombela confirms by its signature that Silulumanzi has complied with the terms of the council's resolution, an extract of which is set out above, and that the consent referred to has become unconditional.
Yeah.
Now, what weight should we attach to that? Because as I read it, I thought that it is now a confirmation that the condition has been complied with. And this person is signing on behalf of the municipal manager, in the sense that it's a PP. You saying that he was not authorized.
Yeah.
But what significance is that, should be placed on that page?
It is obvious from what you're pointing out on this page that Mr. Mhlongo thought he could do that. But if one looks at his conduct after that, he clearly came to the conclusion that only Mr. Diamond could have done that. That's why he participated on the 14th of November. But if one reads this document was aimed at a final decision on 19 September. That's why Mr. Diamond's name is there. They believed that Mr. Diamond will attend the meeting. And they thought if he is there, he will sign at the end of this document. But he wasn't there. And that's why the whole process ensued afterwards. They didn't reach finality because the council's consent was not given yet. Legally, Mr. Mhlongo could do nothing. Only Mr. Diamond could do it. And he had problems. Maybe he didn't want to attend that meeting, but he had difficulty with that process afterwards, quite clear from his exchanges with the legal department. And I've little doubt that he signed the 14 November document as a disgruntled official of that municipality. He was not happy with the process, quite clear from the...
Can I then ask, yes, you've referred us to that letter where he still needs confirmation of something after September. I think it was a letter of October. But as part of your narrative in your papers, this whole narrative about the mistaken, Mr. Mhlongo being mistaken that he could represent Mr. Diamond, is it part of your narrative that in fact what happened concerning the September, what appears to be an agreement in September, was as a result of a mistake that Mr. Mhlongo thought that he could represent the municipality?
Yes, but what actually happened is...
No. The question I'm asking is whether it's part of your narrative in your papers. You do proffer that version in your papers.
That Mr. Mhlongo mistakenly believed he could sign it.
Yes.
Of course, it's quite evident from what he says,
And
that he
in
signs
which page?
PP.
In which page?
In which case it means nothing.
That averment?
I beg your pardon, just...
In which page are you making that averment?
No, we deal carefully with the 14 November decision, and we deal carefully with the distinction between the September decision and the 14 November. That's...
Are you saying we should conclude from your submissions that it was a mistake, or is it something that you've averred?
No, we simply took the point that Mr. Mhlongo had no authority. He wasn't mandated, and that was the SCA found for us on that basis. We argued that he wasn't mandated, he couldn't do it, therefore the 19 September decision has no effect on the municipality. And that's also clear from the common cause facts that I've read earlier, that the municipality after this document confirmed that 14 November was the actual date. So the only thing that happened here is, let's take this. If Mr. Diamond was there on 19 September, there would not have been a 14 November agreement. It would not have been necessary.
Well, I guess that's your version, because when counsel for the applicant was arguing, he said that it's a recordal. The 14 November document was a recordal.
Yeah, but that's, it's an interesting recordal when it says, when you read it against the backdrop of the correspondence where Mr. Diamond considers not signing it, not confirming the consent, that he was grappling with it and didn't want to confirm it. And then comes the legal advice that everything is in order, then only does he exercise his discretion. And if one reads that document, it makes clear that he's granting his consent.
I think you've answered me sufficiently. Thank you very much.
Thank you, Justice.
Thanks, Mr. Mhlanhla.
Mr. Wasserman, we, Counsel for SEMCOP Netherlands, implored us to hold Butleways to the pleadings. And she referred us to paragraph 67 of the founding affidavit, where an amendment is made that it appears that it was pursuant to this letter of 19 September that the first respondent appended his signature and granted the consent, as well as the response thereto that appears at CB 130, paragraph 195, where that amendment is admitted, where the deponent says, I admit that on the 19th of September 2018, the municipality granted consent. Now, what should we make of that evidence under oath?
Well, it doesn't matter whether there was an latching on to the quite doubtful proposition made in the founding affidavit in the beginning stages, before the record became available. It simply says it appears that, and it appears from the document that we've just looked at where Mr. Mhlongo signs PP, it appears that he did sign purportedly on behalf of the municipality. But when we got the record, it became quite clear that it couldn't have happened, and that it was only Mr. Diamond who did it, and he signed on 14 November. So to try and latch onto something that was early stages is totally, and ignore what really happened when everything became clear and the municipality confirmed under oath that the decision was only made on 14 September is really not helpful in this whole exercise.
I can accept, so to Butleways, it only became apparent later after that had been admitted. Now, in the pleadings, where we find that change position to now say that it could not be that the municipality granted consent
No.
on the 19th as Mr. Musala
No.
as under oath.
Justice Noku, what?
Because if I may just add to that, because the criticism was that it does not help Butleways to just peer off the record and look at some documents and not plead the case so that it's then dealt with by.
Justice Noku, there would have been substance in that proposition if the notice of motion on day one read 19 September. It doesn't. It refers to the 14 November decision from the start. And although that snippet is there, we make the case in the first affidavit, the second, and I think there's a third one, that the supplementary affidavits, that the 14 November decision is the only relevant decision. The whole case became crystallized before we got to the court a quo, because the judge a quo dealt with this because of what we've said and what the three parties themselves said about the decision and the effect of the decision of 14 November. So the judge a quo construed the affidavits the way I'm presenting it to you now, latching onto the and relying on the common cause understanding that the decision was taken on 14 November, not the 19 September document, which wasn't signed by Mr. Diamond. There would not have been a 14 November document if it was there.
Lastly, I didn't want to interrupt you because you gave us page references when you were within your 30 minutes. Can I just ask you to give me those page references where we will find the support for the proposition that the decision was made on the 14th of November, just for me to record.
That we will find for you. They all here, could I read them to you? If we go to CB2, you'll find, I'm going to give you the references, page 109. Well, these are the other parties. Are you asking where Butle says so? Butle deals with it from the beginning and rely on the 14 November. I'm sure that you don't ask, you're not asking me to identify where Butle identifies 14 November as the,
That's what I'm asking.
well, that's a different one. Then if you give me some time, bear with me for a moment. You will find at CB 109. That was the case we argued with all the references. On 14 November 2018, the municipality gave its approval of the transfer of shares in Sululamansi to SAW. In this regard, I refer the court to, and then all the pages, the relevant pages. And that was the case not only in this affidavit, but in the others as well. And that was what we argued from the beginning.
And the response to that, where do you know if we'll find that?
The response to this particular, I think that's the three I've read to you earlier where they say it's common core, where they agree with that. Those three references, I can give them to you again. They are on CB 109, the municipality's answering affidavit, CB volume 3, 249, answering affidavit from Sululamansi, paragraph 23, and CB 2, page
Sorry,
1.
you're talking too fast for me.
Sorry, I beg your apologize. Let me start with the first one. The municipality's affidavit you'll find in volume 2 of the core bundle at page 109.
Now, page 109, that's not municipality, is it? That's the affidavit by...
That's the municipal manager. 109 is a municipal manager. That's a municipality. That's a municipality's answering affidavit. Then Sululamansi, you'll find in volume 3 at page 249, paragraph 23. And SAW, it's volume 2, page 142, paragraph 25. And the founding affidavits, let's get ours. As far as Boetle's case is concerned, you need to look at the notice of motion where we pinned the case on the 14 November decision, and that is with reference to what we say in the affidavit, that was the agreement, and that's referred to in the affidavit.
Your case is that the decision was taken on the 14th of November 2018. And that's what has been pleaded by Buhle Waste.
I beg your pardon about Boetle Waste?
That is what has been pleaded by Buhle.
That's what was pleaded by Boetle Waste.
Okay. Now, you haven't addressed us or dealt with the question of the public power point vis-a-vis the contract. I don't know whether you want to say anything in response.
I started off, and that is a way in a question put to me. I started off by saying that I will deal on the saga because there seems to me a common understanding, at least between Mr. Marcus and me, that the June resolution is public, exercise of public power. And the only argument advanced, and that's why I took it further to identify Mr. Marcus's distinction to say the 14 November decision was simply a ticking exercise. Quite clearly it wasn't. So if he was happy to live with the June resolution as the exercise of public power, and so it should be. And we rely in that regard solely on what we've said in the affidavits, the heads of argument, and the reasoning of the SCA, as well as the local judgment. Actually, I counted this morning, actually seven judges have found that is the exercise of public power in the lower division. If we can also count Judge Segogo, who also found that the June resolution and the whole process fall within the regime of the exercise of public power. But I have nothing more to add, that it's quite clear that the municipality, when it imposed those conditions, did so from a position of an organ of state who sought compliance with existing laws at the time. the BBBE Act and its duty to comply with the services it ought to render and supply in terms of Section 9 of the Constitution. That's why it insisted upon the selection of an entity, not persons, but an entity qualified with a reputation and a record. Those conditions are quite clearly spelled out. And what the municipality did there is not negotiating commercially. It did its duty as an organ of state, as a council of a municipality who wants to take care of its people in its province. It could have made it general, 28% generally, but it said no. We want the people of our province to benefit from this. But the entity who gets it must be an entity with qualifications, with expertise. And I'm not going to deal with what really happened because it's quite clear that it was simply lip service paid to those requirements. But what is clear is that the municipality properly understood its function as a local authority and tried to see to the appointment of skilled local people to be allocated that 28%. No question about that.
The delay point, you've heard argument by your colleagues insofar as application is concerned. They said that if one accepts that the decision was taken in November, Bushaways is still out of time. And the explanation for the delay is tests, and based on that, condonation should not have been granted. What's your response?
Well, we would like to refer you, because to attack that and to succeed with that, one would have thought that there would have been proper pleading as to a misdirection committed by both the lower courts. Because it's quite clear from the Mbulelo Paul Gladstone not Yawa judgment in this court, CCT 115/18. The parties were Mbulelo, Makana Municipality, member of the Executive Council, and Pamela Yaku. Now, the whole citation is that what I've read to you. It is 2019 ZACC 43. And the court makes it quite clear that, and the court didn't there interfere with the exercise of a discretion by the lower court that granted condemnation, and emphasized the fact that there was no indication of a misdirection on the part of the lower courts. And once there's no misdirection, this court ought not to interfere with the delay. And if one looks at the facts, what could Buhle have done on 22 November when it got the 14 November document? Jump out of the starting blocks and bring a review? On what basis? The 25 September was before the decision. Normally, attorneys do threaten, but it doesn't mean you have all the details and all the facts to draft papers. Draft papers is something else. You need to understand what is the nature of the case. We're even today debating whether it is a exercise of contractual powers or whether it was the exercise of public powers. Buhle needed to get its ducks in a row and to ascertain whether it really is vested with a review, because the decision of 19 September was taken by other parties, not the municipality. It couldn't have reviewed that. It dawned on Buhle that the 14 November decision is the one they should attack, but then they needed the facts. And you see, we even went to court before Justice Ogogo to get the facts, to get the record. There was the debate all along that we're not entitled to it. And the Judge Akko is quite correct that there was a deliberate attempt to frustrate Buhle not to get the detail in order to support a proper founding affidavit. That's why you have 3 founding affidavits, 2 supplementaries. We submit there's no merit in the delay argument.
On the settlement concluded by Buhle Waste and Semcop Netherlands, that is the order that was, the settlement that was made an order of court in May
2018.
2022.
2022, so like.
2022. What is now the status of that order? If one reads the judgment of the High Court, Para 2, Para 1 and Para 2 of that order, is that order that is the May 22 order, still intact or what?
Justice Matlanta, if one reads the two judgments with the order is there, it's always been there. Nobody tried to to move away or depart from that order.
So that order of May, that is the order that was supposed to conserve the sale of the shares.
Yes.
The only issue that is outstanding is whether or not Bushle Waste ends up being the 28% shareholder, or should it be Brian Kerr?
That's it.
And the November agreement or decision, according to you, will be the one that is supposed to have appointed that shareholder, the 28% shareholder.
That is so. The only thing that November document does is confirm its consent. Now, if one reads the decision, how it is lifted out and placed into the notice of motion, that's the decision that Bushle had to attack, because that's the only decision the municipality made. And had it not been for the May settlement and the May order, it would still have read so today. But the May order did impact on it, and the two judgments clearly understand it so, because even if Judge Legordi didn't refer to it, that's the only case he dealt with, namely the 28% allocation, or the selection of a 28% shareholder. And that's clearly explained in paragraph 32 of the SCA judgment. If one reads the judgment with the reasoning, there's no need to fix the order, but we have no problem if it's clarified.
One of the High Court order, which said that the decision taken by the municipality on 14 November 2018, in terms of which it consented to a change in control of Slumans, is declared unlawful and is hereby reviewed and set aside. You have no problem with it.
No.
It raised to the 28% shareholding.
That's the only ambit that's left of the review, is that the effect of that 19 November decision, which confirmed, it says it consents to the transfer of control, but at that point it had to say so because there was no May order. And we could have, after the May order, we could have changed the relief, we could have argued. Now we are criticized because we haven't pleaded properly, but Semcorp Netherlands sat the whole duration of that argument in court and never complained. They lived with that order the way it was phrased. And they never suggested to us we need to change our notice of motion. And our notice of motion can't be willy-nilly changed. We had to await the judgment giving effect to that. Because the decision is wider than the 28%. The decision is the one set out in the 14 November document.
If you succeed on the review point, because this order, your success depends on whether or not you succeed on the points that you've raised in the review. That is the lack of expertise.
Consultation, oversight, all properly set out in our head.
Just all of those.
All of those stand.
Yes.
Thank you, Mr. Wasserman. Just a few questions from my side. The only resolution that was passed by the local authority was the June resolution, not so?
Yes.
That resolution didn't contemplate the matter coming back to council, correct?
They didn't.
And it didn't come back to council, correct?
They didn't.
Right. Only two things could have happened arising out of that resolution. The one, the municipal manager could verify that the conditions that had been set in that resolution had been met. Secondly, if those conditions were not met, then the consent would lapse, correct?
The content would have?
The consent would lapse.
Yes, because it would have fused.
Yeah.
That would have been the end of it.
Fused, right. So that resolution didn't contemplate any further agreements being undertaken, correct? None were necessary, not so. Because really, the municipality had already consented. It had set conditions. It had said, municipal manager, you tick off whether these conditions were met. It didn't contemplate any further agreement. And if it did contemplate a further agreement, it certainly did not mandate the municipal manager or delegate any authority to the municipal manager to enter into any further agreement. What do you say about that?
But
Before I
it
give
didn't
my question?
prescribe to the municipal manager the format of how he should express his consent.
Yes.
It's just a recordal. That's what was needed. His signature and a recordal that he grants his consent.
Sure.
Whether he did it in the way of an agreement or did it otherwise, that doesn't matter.
No, it matters because your case is that there was an agreement in November. And I'm saying to you that the resolution did not contemplate any agreement because none was required.
No.
All the municipal manager had to do was to say, yes, conditions have been met. He didn't have to say no, because if it was not met, then the conditional consent would automatically lapse as per the resolution. So I'm simply putting to you that the terms of the agreement accurately reflect that, because the terms of the agreement pertinently point out that consent had already been granted, and that this agreement is simply a recordal. Now, you would accept that the recordal of something and the conclusion of an agreement of something are quite different events in law. They arrive there differently.
Yes, but
I mean, I could agree to sell you this phone during the tea break, and in the afternoon you might say, look, Judge, I want to cover myself. Can we record our agreement? And that would simply be a recordal, not so. The law of contract would say that even if we don't record it, you could bring an application for specific performance for me to deliver my phone to you, not so.
Yes, Judge, may I make a few submissions about that? Yes. The first is, it is quite clear that if one sees it as an agreement, housing the consent, one has to construe that in context.
Sorry, you say if one
The
sees it
agreement.
as an agreement housing consent.
Yes, that's what it does. It does house the consent.
Would that mean that the consent is granted in terms of that agreement?
Well, it didn't have to do it, but it did take place that way.
So you're saying that the consent was granted when the agreement was signed?
When Mr. Diamond signed that document, he granted his consent.
And so what then is of the, what do you make of the resolution of council that
Well-
actually granted the consent? And under what authority could Mr. Diamond grant the consent in the absence of any delegation by council to do so?
No, but
And the council resolution didn't contemplate him granting consent, surely?
well, the council resolution authorized him to grant the consent.
Show me where.
Well, we'll look at it. In F it says, the acting municipal manager as accounting officer be mandated to confirm the requirements above have been met as per the terms of the conditions of the conditional consent, granted a conditional consent.
Sure.
So he has to confirm that the requirements have been met. Now, it's not a ticking exercise that was.
Sure, but that's not to give him the power to grant consent as you've submitted now. That doesn't give him any power to grant consent.
No, but what he had to do is, in the way it is struck here, he had to confirm that the requirements set out above have been met as per the conditions. So that is, the first debate is that a decision to be made by him, or is it simply a ticking exercise? It can't be a ticking exercise. You're not ticking boxes. You look at what.
Let's accept he has to apply his mind and make a decision.
Yeah.
That's quite different from granting consent.
Well,
That's the authority of council.
but Justice Colopin, when one reads F and the recordal in that document of 14 November together, that is what he purported to do. That's precisely what he did. He said he consents to the transfer of control because that was the aim of the entire resolution. Is to
Mr. Wasserman, I don't want us to spend the rest of the afternoon, but I'm saying to you that the recordal doesn't record him granting consent. It records a consent that had already been granted. If you look at,
well, could we have a look at that again?
if you look at paragraph, page CB 33, The last paragraph at the end of that page,
If you give me one moment.
core bundle 1, page 33.
Well, are you looking at paragraph 3 on 670?
No, sorry, I'm looking at core bundle 1.
It's volume,
Volume
volume
one.
7.
Sorry, volume 1.
Well, we could do it in volume 1 as well.
Oh, sorry.
Fine.
it's
That's
right
fine.
there. Page 33. And
Oh,
paragraph
wait,
5,
I
it says,
just want to understand that-
concessionaire has, to the satisfaction of COM, selected a local BE shareholder. That was the condition, correct? COM confirms the fulfillment of the conditions, and the parties now wish to formally record the consent granted by COM, not granted by the municipal manager, but granted by COM.
Yeah, but if one reads this with what happens on the 19th of September and the June resolution, the only thing he does here is he says, he's pleading the history in this document, and when he says in paragraph 3, I acknowledge this and I hereby unconditionally consent to the change of control, that's the effective date when it happens.
So you're saying the effective date is November?
Yeah.
Okay, let's leave it at that. We can disagree on that point. And I thought I just wanted to make an observation. You mentioned that 7 other judges took this view. Unfortunately, in this court, numbers don't count. Those numbers are not in this court.
I didn't mean to
I know you didn't mean
suggest
that
that at all.
Thank you.
Mr. Wasserman, still in line with the questions raised by Justice Colopen. I mean, even if you rely on CB 670, the effective date there is set out as the 28th of September. So that doesn't help you. Go to page 670.
6-7?
Yes, 670. I think that's where you place your strongest reliance, eh?
670 is in volume 7.
Yes.
I've got that.
But look at 2.3 at page 670.
Yeah, the effect thereof, if I may answer the question,
Yeah, the effective date.
yes.
Yeah.
What it does is, and whether that's legally possible or not, that's not relevant here at this point in
Well,
time,
it's
but
got to be legally possible. It's got to be legally possible, Mr. Wasserman. I mean, this is a standard clause in many agreements, that the effective date of this agreement is whatever it is set out to be.
yes, but that's the only thing it does. It records,
Sufficient, though,
it
even if it's the
records,
only thing it does.
Justice Dambuza, if I have my dates correct, the 28 September 2018 is the last of the 90 days. And the only reason why you have that date there, it's got nothing to do with the 19th of September decision. It is simply to give, under the understanding, as was put this morning, that the whole thing might have collapsed. They might have considered the same problem, that everything had to take place within 90 days, and therefore the 28th September is construed as the effective date. So it's retrospective. That's what they're trying to do here.
We've got to speculate then as to why the date is there. The date is there, and it simply says the effective date of this document is the 28th of September. Oh, that's all I'm saying.
Now, I see the point.
In other words, the 14th November date that's on the document is not the effective date.
No, but with great respect, that I take strong, I dispute the construct of that approach. May I say why?
Yes.
The fact that you put in an effective date doesn't mean that when he signs on the 14th, on the 28th of September.
That's not what I'm saying.
No, but what he does is he gives his consent on 14 November for the first time. On any body's basis, Mr. Diamond, for the first time, gives his consent on 14 November. And the only thing this means...
I didn't want to go back to the consent, because that's the argument that you had with Justice Colopen, as to whether it was required or not, or whether the conditions in the suspensive conditions became fulfilled at a particular point in time.
Yeah.
All I'm saying is that in our interpretation of this document that you're referring us to, we've got to interpret it comprehensively, and it sets out what its effective date is. I understand what you're saying, and I hear you, but you also have heard me.
I see. It's a very interesting issue. I mean,
You didn't say anything about it.
no, but simply because I may see it differently. I
Yeah.
see it differently because the notice of motion attacks the day when the decision was made. The effect of the agreement between the parties, when it will be regarded as effective between them, is irrelevant for purpose of administrative law when the decision was taken. That doesn't deal with that at all. We here solely on a public law approach, administrative action, and nothing to do with the effect of the agreement, whether they backdate it or not. It's neither here nor that.
So you say we must just write it out of the agreement?
No, it's got nothing to do with the decision before you. The decision is when was it taken, not what they agreed when it will be effective.
Okay.
And the only outflow from that would be, Justice Dambuza, is we could be criticized that we didn't put in the notice of motion 28 September instead of 14 November.
You're not saying that an effective date that's put in an agreement is irrelevant?
No, not at
The
all.
interpretation of the document.
It may be relevant for commercial considerations. There may be rights between the parties dependent on that date, but it's got nothing to do with the administrative action that was taken on that day.
Okay, all right. Thanks.
Mr. Wasserman, I'm struggling to reconcile the May order, which preserves the sale of shares agreement. Because to me, it seems as if what gave rise to the requirement for the municipality to give consent was the change of control, because Silulumanzi was, the shares, they were owned by Sam of Netherlands. So it was that change of control that gave rise to the need for the consent. Now, if the sale of shares agreement is preserved by the May order, what is then left
The
to
conditions,
set aside?
yeah, what is left is the effect of that agreement. I agree with my colleague. SAW became vested with the whole 100% shareholding because of that document. And in fact, there was a change in control, but it was conditional. And the terms of the conditions are set out in the June resolution. And if the June resolution wasn't met, those conditions, the whole thing would have fallen flat. There would not have been a change in control, simply because of the effect of the SPA. But what we did in May is to agree that we don't attack the SPA. We agree to the transfer of the equity to SAWW.
So let me just interrupt, but was the transfer not conditional upon those suspensive conditions being fulfilled? Because the fulfillment of conditions had to take place, pursuant to which then the change of control could ensue.
That is so. There is the June resolution, and you're quite correct. The effect, if one reads the two together, it is creating difficulty. But fact of the matter is, Butley, the only party attacking what happened post the June resolution, was happy to live with the SPA. And that became a commercial transaction between Butley and SAW and Semcorp Netherlands, to the effect that we will not attack that transaction, the SPA. So the focus of our attack in the review was then limited only to what happened post the 28 June resolution. We didn't attack what happened before that. We agreed that that transfer was validly made.
Still quite, I mean, was it possible for that transaction to be effected without the fulfillment of the suspensive conditions? And what is Butley's case regarding the fulfillment of those conditions? Have they been fulfilled or have they not been fulfilled?
What Butley's stance was, as recorded in the May order, is that anything impacting on the SPA has been fulfilled. The SPA was no longer in issue. That transaction became valid and enforceable as far as Butley and Semcorp Netherlands are concerned. And none of the other parties took issue with that. It was made an order of court. So all the parties agree to that. And it is an attack, administrative action, attack. It is up to Bootlet to agree whether it wants to attack the entire process or certain section thereof. And we limited our attack only to the selection of the 28% shareholder.
But if you read that paragraph 1 and 2 of the order, it is a granting of consent to the change of control that is being set aside.
Yeah.
And the change of control is a change of control from Semcorp Netherlands to SAWW. It's nothing else. It's not about what happens within SAW. It's a change of control because it's change of control from Semcorp Netherlands. So if that is set aside, can that live with the preservation of the transaction? That's what I'm struggling with.
Just look, technically, as my colleague had to concede, if one reads the order on its own, it creates a difficulty. But if you read the two judgments and the reasoning in paragraph 34, the SCA judgment, everybody understood, all the parties and the court understood, that the focus of the attack was limited to the 28% selection, shareholder selection, nothing else. And there was nothing in any of the judgments affecting the May order at all.
Mr. Wasserman, you were in the High Court when the case was argued.
Yeah, at the High Court, yes, I was.
Insofar as it may be relevant, I just want to understand what the arguments were in the High Court. In other words, what position the parties adopted. I'm not sure if all parties before us now were represented by at least one of the counsel who's here today, but I will take it really on the assurances of counsel if that can be done. In the High Court hearing, was it argued for the present applicants, who would have been the respondents at that time, that if there was administrative action, it occurred on the 19th of September 2018, and that delay should be reckoned from that date?
It's an afterthought. Only happened in the SCA first time. It's an afterthought. It was never raised in the Court in the High Court.
There was, of course, an argument that what happened on the 14th of November 2018 wasn't administrative action or reviewable. And the same argument, if the 19th of September had been the relevant date, would have been made about that. It would have been said it's not the exercise of a public power. But insofar as any of the present applicants lost that point in the High Court, was the argument that you should have targeted the 19th of September 2018?
No, we should have targeted the resolution, the 26th.
Well, I think nobody can sensibly argue that the resolution was could be the subject of a review because nothing had gone wrong by that stage.
Yes.
If something went wrong, it went wrong after the June resolution. And the question is, when did it go wrong? And was the act of its going wrong something that is subject to review?
Yes.
But in regard to the date, your understanding at least, or you are assuring this court that it was never an argument that if there was something to review, it should have been directed at a decision on the 19th of September 2018, or the delay should be reckoned from that date?
That was not the issue or the debate in the High Court.
But perhaps we will hear in reply whether any of the parties say different. Assuming for the moment that the relevant decision was the 19th of September 2018, and I don't want to re-engage on whether it was or wasn't, but assuming it was the 19th of September 2018, that fact would have two potential significances for the case. The first might be that your notice of motion was directed at the 14th of November 2018, so you didn't plead an attack on the 19th of September 2018. I must say that my initial reaction to that would be to say, well, it made no difference to any of the grounds of review. Whether it was the earlier date or the later date, everything was ventilated in the papers. So it would be a technical error in the notice of motion. Given the way I've put it, I suppose you would say yes.
I have no choice. I must say, I do it under pressure.
The second significance, though, would be the question of review, of delay. The High Court and the SCA assessed delay on the footing that the relevant decision took place on the 14th of November. If the relevant decision took place on the 19th of September, 2 months earlier, then the question of delay was assessed by the courts below on a wrong factual premise, which would mean we would be at large to assess the question of delay. It wouldn't be a matter of interfering with the discretion. We would have a misdirection, and we would have to assess the matter afresh. Now, the way I've put it to you is less favorable on the second part than the first.
Yeah.
Do you agree with
Yes.
On a different matter, to some extent being covered by my colleague Justice Nuku, it's the High Court order of May 2022. Just give me a minute. So paragraph one, the order is, I think it's the ordinary bundle, not the core bundle at page 841. It starts by saying that the relief sought by Buchle Waste in this application does not extend to, I think the word to is missing, the following: the SPA of February 2018 and the Council resolution of June 2018. And then paragraph 2 of that order says that February 2018 SPA and the June 2018 resolution are valid, enforceable, and binding. Let's forget about this order insofar as it relates to the June 2018 resolution, because nobody has attacked it. It's a valid and binding resolution, but in its own terms, it's a valid conditional resolution, or it's a conditional consent.
That is so.
The resolution in its own terms is conditional.
Yeah.
But what is said in the order is that the February SPA is valid, enforceable, and binding. Now, as I think Justice Nuku has raised with you, if you take the matter in its ordinary legal sense, you would say, well, in June 2018, you have a valid council resolution giving a consent, but it's conditional. And if the condition isn't met, then there isn't consent. And although the SPA may be a valid agreement, it still requires consent, and the consent will fall to the ground. Is that consistent with the May 2022 order, or must we read paragraph 2 of that order, that the SPA is valid, enforceable, and binding to mean that, whether it's contractually logical or not, the sale of the shares and the consent to the transfer of the shares is unconditional? In other words, that any conditions to which the SPA of February 2018 was subject, including consent, has been fulfilled.
That is so. Between the two parties relevant to that agreement, which was made in an order of court, that's the understanding.
I'm surprised it wasn't put a bit more explicitly, but on the other hand, my understanding is that counsel for SEMCOR absented themselves from the proceedings after this order, so they must have thought that it had that effect. Otherwise, they would have still been very interested in the question whether the review succeeded or not.
Oh, yes, as was indicated earlier, they were present as on a watching brief, didn't participate.
They stayed for a watching brief.
Yeah.
Now, whether it's legally logical or not, I assume that in review proceedings, the court under Section 8.2 of PADJA, which mirrors Section 172(1)(b) of the Constitution, as just and equitable relief, a court could notionally say it will be just and equitable to recognize unconditional consent, despite the council resolution, and to confine further disputation to who is going to be the 28% shareholder.
We agree with that.
Is that a proposition with which you would go along?
Absolutely.
So whether it was done explicitly or not, it seems to me it could have been done under the statutory provisions for just and equitable relief.
Yes, it could have been done.
Yes, thank you.
Thank you, Justice.
Reply, Mr. Marcus.
With your leave, my learned friend, Ms. Puddifin Jones, will do the reply.
Thank you very much, Justices. With your leave, I intend to briefly address three topics and not tread any of the ground that's already been dealt with by my learned friends. The first topic arises from a question raised by Justice Colopin in the context of the public-private distinction and the relevance of the equality of bargaining positions between the municipality and the Silulumanzi applicants. And as I understood the question, the query was whether, when SAWW accepted the condition, they did so to their prejudice. And Justices, if I might answer that question by taking you through certain of the correspondence in the record. The first is the letter of the 2nd of March. It appears at Core Bundle Volume 7, CB 637. And I would ask in particular if one could turn to page 639. And here what we see really is an engagement between the municipality and the Silulumanzi applicants as to the terms on which they are willing to accept the municipality's proposals. And I won't take you through all of them, but this continues for a number of months, right up until July. The next letter is at CB 641, a few pages later. It's a letter of the 8th of May, 2018. And in the answering affidavit that's filed by Silulumanzi, they explain this correspondence at paragraph 82, and they say that SAWW specifically pointed out that it did not accept that the municipality was entitled to impose such a condition, but that it nonetheless accepted the condition because of its belief in transformation. The next letter appears at CB 647. It's on the 20th of May, 2018. And here what we have is an entire proposal set out by the Silulumanzi applicants, SAWW, as to how the 28% shareholding process should work. And then finally, this concludes in the previous core bundle volume, CB6, at CB 608, which is the letter of July, which again, the Silulumanzi applicant saying to the municipality, we accept your condition, but this is how it should work. And what is very important here is that it is not simply a, yes, we'll do what we told municipality. Throughout this exchange of correspondence, what SAWW is saying is that in exchange for us doing this, what we want from you, the municipality, the quid pro quo, is that you must take this decision within 90 days. They emphasize in the correspondence that the municipality has historically delayed, and the SAWW applicants say, we are happy to accept a 28% local shareholding. We welcome it in light of transformation objectives. And in response, we ask you, the municipality, to take your decision timelessly. So, Justice Colopin, we submit that this shows that it is not the kind of unequal bargaining position that one might sometimes have with organs of state. These are two contracting parties, each imposing requirements on the other in their mutual interests. And staying on that letter, the July 2018 letter, the second issue I wish to deal with responds to Justice Savage's question regarding the issue of delegation. And the question that my learned friend raised, whether it was in fact only Mr. Diamond who could sign the document, the 19th of September issue. And I want to answer this question in two ways. The first is what we say Justice Cameron called a killer point, which is simply that this issue was not raised on the papers. Never before the High Court or the Supreme Court of Appeal was there an argument that the 19th of September confirmation by the municipal manager was unlawful or a bad decision because Mr. Mhlongo was not authorized. What we hear today is an argument that it was not necessary for Buhle Waste to challenge this decision because it was an unauthorized decision. But we say that that respectfully puts the cart before the horse. Precisely because it was an unauthorized decision, it ought to have been challenged. And Justice Rogers raised the question as to whether there was any prejudice from this. And we submit that there was significant prejudice. Had the issue of delegation been raised, had the correct decision been challenged, it could and would have been responded to in the answering affidavits, including by the municipality, who's not here today. But it wasn't raised, so it wasn't an issue that was dealt with. Secondly, under this issue, not a killer point, but it is respectfully relevant to see how the parties themselves understood the 19th of September 2018 confirmation from the municipality. And certainly what we see in the record is that Silulumanzi's understanding at the time was that that was the written confirmation that was prefigured in the June 2018 resolution. And we see this in the letter that Silulumanzi sent on the 28th of September 2018. It's at core bundle 664. And what Silulumanzi says is that it refers to the signature on the 19th of September letter, and it confirms that the consent had been made unconditional by their signature. So Silulumanzi understood that the 19th of September written confirmation was the rendering unconditional of the June resolution. And we know too, and Justice, as you've been referred to, the fact that the municipality itself expressly admitted in its answering affidavit, paragraph 195, CB 130, that on the 19th day of September 2018, the municipality granted consent. The word consent is perhaps unfortunate. What we're referring to is, of course, written confirmation. And I point out, too, that it is not correct that the 19th of September was a rushed date because that was the final day for the expiry of the 19 days. That is not correct. That was the 28th of September. So there was still sufficient time. The issue then arises as to whether the allegation around the 19th of September decision was raised in this court for the first time. Now, I wasn't in the High Court, and neither was my leader, so I can't assist justices with what happened from our side. But what I can do is add to the references in the founding papers and the answering papers that justices you've already been given in relation to what my clients, the Silulumanzi applicants, said. And the first place to start is Silulumanzi's initial answering affidavit. It's core bundle volume 3, page CB 252, para 35. And what Silulumanzi says in that first affidavit is that the decision that is the subject matter of this review application was taken on the 28th of September 2018. Now, I accept that the 28th is not the correct date. That was the date for the expiry of the 90 days. But it clearly asserts that the decision was taken not in November. Then the second answering affidavit by Silulumanzi, paragraph 14 at CB 476. What is said there is that the applicant seeks to set aside the alleged decision by the municipality. And at paragraph 21.3, a few pages later, Silulumanzi squarely states, the applicant has sought to review and set aside a decision by the municipality which was never taken, and the relief sought is thus fundamentally misconceived. Justices, so we say that if the decision had been attacked, and if it had been attacked on the basis of no authority, we would have had an opportunity to answer it, and we would have squarely addressed this. But that was not the decision that was challenged in the notice of motion. The issue was squarely raised in the High Court on the papers, and that the applicants squarely answered the case that they were brought to court to meet. Thank you, Justices.
Ms. Patterson-Jones, you say that if there had been a challenge to the 19th of September 2018 decision, the authority of the Deputy Municipal Manager, it wouldn't have been canvassed. I mean, it would have been traversed in affidavits, and there is prejudice. But just to make clear, the context of what I put to Mr. Wasserman assumes in your favor that the decision was on the 19th of September. That is what you say the case is. And you say it's undisputed based on paragraph 67 of the founding affidavit in the municipality's admission of that. My point to him, and it can be to you as well, is that on the assumption that the correct decision then, or the correct municipal act was on the 19th of September rather than the 14th of November, what prejudice is there on the merits of the review? Because all the issues that were used to attack on review the decision of the 14th of November would have been exactly the same grounds directed to the consent given on the 19th of September. Because I think on your approach you would say that all the agreement of the 14th of November did was to record something that had happened on the 19th. So it's a formal description error, but apart from delay, what difference does it make?
Justice Rogers, it does respectfully make a difference in relation to authorization. If
To?
authorization of the signatory.
No, but your case is that there was no challenge to the authorization, and I'm assuming
Yes.
it was authorized, and therefore that was the decision.
Then
In
Justice
that footing,
Rogers.
on the merits of the review, there's no significance.
Yes. Justice Rogers.
The significance would come in on the question of delay.
Yes, indeed, Justice Rogers, and it is a point that was taken by my clients in their answering affidavit that the initial day for the reckoning, the day that the clock started ticking, was September, not November,
In the answering affidavit in the High Court.
in the High Court.
Could you just give me that reference? Or perhaps you can give it once, unless you think you can lay your hands on it promptly.
I can't immediately, sorry, Justice Rogers. Oh, I can. The answering affidavit, for example, Simko Silulamanzi, paragraph 96.1, call bundle 271. It's a conclusion, but it is the point. For reasons I've traversed above, I submit that the date from which the applicant's delay ought to be reckoned is the 28th of September 2018 and not 22 November 2018, as the applicant suggests.
Yes, that date of the 28th is a bit of a mystery because it's not a date on which anything actually happened, is it?
No, it's not. It was the expiry of the 90-day period, Justice Rogers, but yes, nothing administrative occurred on that date.
I am concerned, but I appreciate you can't assist on what actually happened in the High Court, because if the attitude of the present applicants was all that the relevant decision was the 19th of September, I would have expected a considerable focus on that being the relevant date. And it does, so far it seems to be absent. We have Mr. Wasserman's assurance that that wasn't how the case was argued. And, well, I suppose if Ms. Hofmeyer had a watching brief, she can perhaps assist us. I don't know if any other counsel can.
Justice Rogers, Ms. Hofmeyer, my learned friend Ms. Hofmeyer did indeed pass me a note saying that she would address this, so.
Thank you.
Yeah.
To her astonishment.
Thank you very much.
Thank you, Justice Mhlantla. I plan to address only 2 points. I was also in the High Court, so I have also argued before all of the courts in which this matter was heard. And Justice Rogers, in light of your question, to my recollection...
Just a second, Mr.
Pardon me.
Timekeeper.
I intend to be much less than 10 minutes, if that's of any assistance. Thank you. Justice Rogers, to the best of my recollection, the point of the date of 19 September wasn't raised in the written argument, but I do recall that my learned friend for Semcorp Netherlands alerted me to the point in the hearing, and I believe it was raised in oral argument in the hearing. That's as far as I can take it, but certainly before the SCA, the point was taken squarely and argued fully in the written argument and oral argument. The first point then is to deal with the argument of my learned friend for Buchle Waste seeking to undermine the contention that in fact the relevant decision, if it is such, was taken on the 19th of September 2018. My first response to that is that it's not open for a legal representative to present an argument that is at odds with the affidavits of his client. You've seen the allegations in the supplementary founding affidavit of Buchle Waste that there was confirmation of the condition by the municipal manager. So that's the first point. Then in argument, it seemed to me that there was an attempt to be made to bolster that case through suggesting that it was only in the process of receiving the record and supplementing the papers that Buchle became convinced that the 14th of November decision was the decision that should be challenging. The difficulty with that argument is twofold. The first of which is that attached to its original founding affidavit, one finds the 14th of November decision. So right from the beginning, it had that decision in its possession for purposes of the review, and it identified that as the decision which it wished to challenge. The second difficulty is that it then received the record. That's what it says at the start of its first supplementary founding affidavit, and it's in that affidavit, having received the record, that it then makes the pertinent allegation that the municipal manager, by signing the letter of 19 September, granted the consent. So the attempt to suggest that the process of obtaining a review record had something to do with the identification of the relevant decision simply doesn't match up with Buchle Waste's own case. So that's the first point. And the second one, which I wish to make, relates to a matter which arose in my learned friend's argument on behalf of Semcorp Netherlands. And it appeared to me that there was a suggestion in argument about the nature of a potential order for remittal, and that may in some way involve the selection process which preceded the confirmation of the condition in September or November of 2018. Now, I wish to make a few points in respect of that. The first is that that's never been the case on which Buchle Waste has approached any court. It approached the court seeking to review and set aside only the confirmation decision, if I might call it that, be it in September or November, not any preceding decision by any other party in these proceedings. And that's highly significant because what had happened before that decision is that SAW and Silulumanzi, as the parties who were administering the selection process and based on the recommendation of the PwC, had made a selection. And I would refer you in that regard to Core Bundle Volume 6 at page 541. This is part of a memo prepared by SAW dated 17 September 2018, and at paragraph 8 of that memo is recorded that based on the assessment of the findings, the recommended way forward is as follows. Brain Gear Investments Limited is selected as Silulumanzi's BBBE partner. And then further, at Core Bundle Volume 7, page 661, and this is part of the letter of 19 September, at paragraph 4.1, is stated, on a conspectus of all the facts and circumstances referred to above, SAW and Silulumanzi has elected to select Brain Gear as its local BEE partner. And none of those decisions have ever been challenged by Buchle Waste. And the consequence of that, in my respectful submission, is that if there is a remittal order granted, and the municipality must reconsider whether the condition in the June resolution has been met, what it will be required to do is decide once again whether the extant and unchallenged selection of my client Brain Gear as the proposed local BEE partner fulfills the condition or not. What it doesn't, in my respectful submission, permit of is for the municipality, or any other party for that matter, to decide that Buchle Waste must now be the local BEE partner. So it's either the case of the existing selection fulfills the condition, or it doesn't. What the consequences of the latter would be is difficult to consider, but it is relevant to the question of the tension between the May order and an order for review. Because if one were to postulate that the municipality rejects the selection, now on a remitted consideration, then SAW would be the sole shareholder in Silulumanzi and there'd be no local BEE partner. Those are my submissions in reply, unless there's any aspect. Thank you.
Ms. Hofmeyer?
Thank you, Justice Mhlantla and members of the court. There are just a few aspects to pick up on in reply. The first is to deal in a little bit more detail with the 19 September confirmation by the municipal manager. Because in the course of my learned friend Mr. Wasserman's argument, he was taken on at least 2 occasions by members of the court to, well, with a request that he take the court to the pleadings in which the statement that the municipal manager was not authorized was squarely made. Mr. Wasserman, with all due respect, was never able to take the court there. The reason why is because it is not to be found anywhere in the pleaded case for Buchle Waste. That is a new argument that has come up, and as I indicated in my first address, needs to go into the review record to be made out at all. Justice Nuku then took Mr. Wasserman to the common position, as I'd taken the court through to it on the papers. It's that first statement by Buchle Waste in its first supplementary founding affidavit that the municipal manager's consent was given on the 19th of September. He was questioned about that, and Mr. Wasserman's answer was that at that stage, that statement, remember the language is, it appears that on the 19th of September, he tried to suggest, as I understood his argument, that that was because that happened early on in the proceedings and before the record had been produced. Justices, that is simply incorrect. That is found in the first supplementary founding affidavit of Buchle Waste, an affidavit deposed to after it had received the record. So he cannot distance himself from that statement by saying it was made early on before they got the record, and the revelations about Mr. Mhlongo signing PP only became known to them at the date of the record. That is just wrong. It came in the first supplementary founding affidavit, and so pursuant to the record being produced. But Justices, it gets worse with respect for Mr. Wasserman, because Semcorp Netherlands, in our answering affidavit, took this point. And I'd like to take you to that reference, if I may. We will find it in the Semcorp Netherlands answering affidavit in volume 5 at page CB 428. Justices, there, Semcorp Netherlands said the following. Paragraph 122. So now we are well past records have been disgorged. Bootle Waste has supplemented for a second time, and now Semcorp Netherlands comes to answer the case. And at CB 428, paragraph 122, the following is said. The entire catalogue of facts set out above shows that all the parties understood the municipality's role to be one of oversight and consulting. It never had the authority to make the selection. The selection was made by the shareholder, SAWW, that would be selling the shares. And then this is the important part. It was made, in other words, the selection was made on 19 September 2018. On that date, the municipality was informed of its selection, and its acting municipal manager thereafter confirmed that the condition attached to the municipality's consent to the transfer of control between Semcorp Netherlands and SAWW had been fulfilled. In no uncertain terms, municipal manager did what the resolution required him to do after alerted on 19 September that the selection had been made. Justices, I can tell you that is not disputed in the replying affidavit at all. The reference there is to the ad seriatim sections of the replying affidavit of Bootle Waste, and there is no answer to that paragraph of Semcorp Netherlands answering affidavit. Justices, while I'm in the Semcorp Netherlands answering affidavit, on the same page is where we took the delay point back to September of 2018. So if I could take the court there. If you go further down, it's over on the next page at CB 429, you'll see there's a heading halfway down that page, delay. We deal there with the months post-June 2018, decision originally of the council, and then at paragraph 128 we say, I must pick up at the end of 127, we say that at paragraph 6.1 of the first supplementary affidavit, the applicant submits that it became aware of the decision in September 2018, and then we say at paragraph 128, it was therefore from at least September 2018 that the applicant learned of the municipality's consent decision. It delayed for 10 months from that date to institute this review. That delay is unreasonable and has never been adequately explained in the founding papers because the founding papers attacked the wrong decision. So, the state of the pleadings, in summary, are that Bootle Waste always struck at the 14 November decision. They now try to strike at some lack of authority for the 19 September written confirmation by the municipal manager, but they do so with no pleaded basis to support those arguments. That the 19 September confirmation by the municipal manager was understood to be just that and to be in fulfillment of the suspensive conditions was the common cause position throughout these papers. I've given you the reference in Bootle Waste's own founding affidavit, I've given you the reference in the municipality's answer, and now in reply I've taken you to where Semcorp Netherlands itself took the point in answer, and there was no pushback in reply from Bootle Waste. With respect, we say that puts this point at its end for Bootle Waste. Justices, the next point to pick up on is this submission from my learned friend, Mr. Wasserman, that what the municipal manager did in November was grant consent. With respect, Justice Colopin, you had an exchange with Mr. Wasserman about this. And with respect, we would align ourselves with the analysis as you presented it to him in that series of questions. What that resolution of council on 28 June did was granted consent. It granted consent conditional. It never anticipated the municipality making another decision in this case. All that it tasked the municipal manager to do, and we saw that clearly when we went to the resolution itself. Justice Colopin, in answer to your question, my learned friend, Mr. Wasserman, endeavoured to take the court to those clauses of the resolution. But with respect to my learned friend, I think found it quite difficult to bring home his point that what the municipal manager had been charged to do is grant consent, because that is the one thing that he was not mandated to do. What he was mandated to do at F was to confirm that the requirements above have been met as per the terms of the conditions of the conditional consent granted. past tense. It's been granted. There's a condition. There are 90 days in which it can be fulfilled. Municipal manager, confirm that that has taken place. And that brings me to a point in answer to Justice Rogers. Justice Rogers, I understood from one of your series of questions that the proposition was put that if there's enough on the facts in the High Court pleadings to make 19 September really the decision that did the work in this case, it's possible to read this case possibly as striking at that decision. But there are a number of problems that come with that approach, with respect. The first is that that is not the clearly pleaded case of the applicant. The ground on which it attacks that decision at all is a ground that I've shown this court already was an unpleaded ground. But worse than that, they get into difficulty with their public power exercise argument for a reason that my learned friend Mr. Marcus made at the beginning of today. It's most likely that what the municipal manager was doing when he gave that confirmation is something not discretionary. It's more akin to the clerical, mechanical type of task that you give your administrative officials. The real work is done when the council convenes and it decides, am I going to tolerate a new controller of my concessionaire, who I've given the task to dispense water services for 30 years. That's the decision that matters, that has discretion attached to it. In its wisdom, the municipality says, I'll do it, but I'll attach a condition to it. And then it asks its administrator, the municipal manager, to confirm in due course that that condition is met. It even leaves the selection of the participant for the 28% to a party who will consult with the municipality, who will advise it along the process, but who takes the ultimate decision. So if they had actually struck at 19 September, they'd have a difficulty then with the reviewability of that act, because that act, properly so termed, is no more than clerical and a mechanical recordal. So justices, this case, with all due respect to Buhle Waste, was shot through from the beginning with misdirection and ill-conceived relief. Justices, if I may be permitted, Justice Mhlantla, just to give the proposed wording that the court requested insofar as reading paragraphs 1 and 2 of the High Court order is concerned. Justices, it's not all that easy a task because those two paragraphs that were retained from the High Court order take as their premise that the 14 November Act was an act of granting consent. And for all the reasons you've heard today, certainly our submission is that can't be so. But the way we have come up with reconciling what was done there with the scope of the May order is along the following lines. And it's to use that device that lawyers often use to constrain the extent of the invalidity by using language to the extent. So we thought something along these lines. To the extent that the decision of the municipality on 14 November 2018 confirmed the approval of the transfer of 28% of the shares in Silulumanzi to a Mbombela-based BBEE entity, it is reviewed and set aside. By that sort of language, you're managing to confine that part of the case which Buhle Waste has confirmed to you in the argument today was the only thing they were ever interested in. And then we would couple that with a second paragraph, the process for the selection of the 28% shareholder is remitted to the municipality. That covers the essence of what the High Court was doing and the SCA was trying to keep in play with paragraphs 1 and 2. It's a reviewing and setting aside, but it's done to an extent. And then the second paragraph is the remittal, that the process of selection of the 28% shareholder is remitted to the municipality. Justices, the last point we would make on this, though, is that our submission is that order should not withstand scrutiny on appeal. There is too much that is problematic about it, and there's too much about Buhle Waste's case that never got the right target for its attack. On no version was the 14th of November the date on which the confirmation of the condition being fulfilled was given. We've seen on the papers that happened in September, and it happened within the period of the 90 days in which it was required to take place.
Ms. Hoffman.
On the second part of that formulation, the process of selection of the BE shareholder is remitted to the municipality. Now, under the June 2018 resolution, the process and selection was in fact not to be run by the municipality at all.
Yes.
Are you meaning that, so by the formulation that you gave us, what do you mean that the municipality must do and what must anybody else do?
Yes, Justice Rogers, we endeavoured to keep as much discretion for the municipality on remittal by framing it in that way. It seems to us it would be legally competent for the municipality on remittal to take a different view as to its role. You see, and sorry.
Including saying we will now determine who the 28% shareholder is, not SAWW.
Well, if this review, with respect, had been better framed from the outset, that might have been the way in which the challenge was brought. You see threads of it. When Buhle Waste criticizes the municipality, it criticizes it in part for not doing that which it ought to have done. It does that by working in the language of the resolution, but what's really at the core of it and why it says this involved public powers is that the municipality should have played a more active role in its selection. It's almost an abdication argument. The formulation of 2, to be frank, is just designed to give greater discretion to the municipality, but we would have no difficulty on a tighter tethering to the terms on which the 28 was originally identified for selection. It could be left to the others to do it.
Given that more than 7 years have passed, it would seem to make the most sense for the 90-day process to start afresh with new bids.
Absolutely so. Absolutely.
Not necessarily that to say after 7 years that the only people who should vie for contention are these two parties whose circumstances, for all we know, may have changed.
Might have changed, indeed. That is why, in part, remittals are often best left with greater flexibility to them, because you don't know what's marched on factually between the original date and when you go back.
I just think the danger of your very open-ended formulation might give to the municipality a greater power than Mr. Marcus's clients would like.
Yes,
in terms of municipality making the choice rather than
certainly.
SAWW.
Certainly. And Justice Rogers, I don't, if I may, want to miss the opportunity to say, this would be, an outcome like this, with all due respect, would be much more than Buhle Waste, we say, was ever entitled to on these papers. It's a reframing of a case for them with a return in circumstances where if pleadings mean anything in reviews, the short answer to this application is that it should have been dismissed. It never got these complex aspects of how you keep in place the transfer to SAWW, but let Buhle Waste stand in the position of brain gear. That required difficult consideration. It required careful framing of remedial relief. The fact of the matter is you got none of that in these founding papers. Thank you.
She takes her computer and iPads. Where's Panela going? Okay. I'm gonna go. Okay, see ya. I think it must be no. Yeah. The one I got because this is not it. Yeah, I'm dead. KK, KK, if you see Parele, can you tell him to please come help me? Hey? I don't know. I called him, but he's not answering. Hey? I actually was worried I'm gonna I see what you're saying. But is there nothing? I'm really interested to see, and maybe the bridges. That's such
Can you help?
Yes, please. Please, please, please.
Should I take that?
Yes, please. Thanks, Parela. I can take this.